Good afternoon, and thank you for joining us. My name is Edward Adams, and I'll be your host for today as we look at our ethical standards in a changing regulatory environment. And so today we've got Nishaat Limbada, who heads up our legal and compliance. She will be taking us through COFI, amongst other things. And then following that will be Alix as well. So over to you, Nishaat.
Great stuff. Thank you very much, Ed, and a very warm welcome to everyone. It's fantastic to be here speaking to you about something that I'm quite passionate about. Okay, so to kick off, I would be absolutely remiss in my role as the money laundering reporting officer if I didn't address the big grey elephant in the room. I know that this is an ethics webinar and we're all here not only to talk and discuss ethics, but also to get our CPD points. So I really will draw the link back to ethics. South Africa was grey listed on Friday. And I'd like to spend a few minutes just actually speaking about that. And what the grey listing actually means, and there's a lot of information about this in the public domain, is that there are deficiencies which were identified within South Africa's anti-money laundering, counter-finance, terrorism, and proliferation financing system. We do know over the duration since the mutual evaluation report was published that the financial services system responded exceptionally well. However, we are grey listed because there's still 8 areas of strategic deficiencies which we need to still cover. So what's all the fuss about? Anti-money laundering and terrorist financing really is about more than simply compliance. So to give you a reminder of what money laundering is about, money laundering really is about the placement, the layering, and the integration of illicit funds. It sounds really clinical, and it's something that we've all been trained to be aware of on the various pieces of money laundering training which we've gone on. But money laundering and terrorist financing actually can have and does have very adverse impacts on society, really by virtue of how these illicit funds are generated. Money laundering and terrorist financing effectively corrodes the society and the system which we work very hard to build, and it taints and affects the most vulnerable people in our society. South Africa is absolutely not immune to any of this. When we think about illicit funds and money laundering with an ethical consideration and lens, think about illicit investments, the drug trade, wildlife poaching, terrorist financing, human trafficking, and modern slavery. So whilst there's been a sprint by financial services to address the deficiencies, to bring our AML rules and regulations up to scratch with the 40 FATF recommendations, because you will remember that South Africa is a member of the FATF, we really need to keep in mind the spirit of why combating money laundering is very important. In my view, strengthening the overall money laundering system really helps us with the fight against terrorist financing and money laundering. I know that there are a few questions on the grey listing, and I imagine that there will be a few that will come through during the Q&A, which Ed has invited you to send through. But I'd like to just inform all of you that we do have a very detailed session that will be held next week, Tuesday, which you can actually sign up for. And that session is really designed to get into the nuts and bolts and the regulation and the how-to, and how do we deal and respond to this with changes to effectively the FICA legislation. Okay, now that I've addressed the grey elephant in the room, let's get into what I'd like to chat to today. Okay, so I think we need to start at the beginning of the story. In 2011, South Africa started on a journey to actually look and understand whether or not there were any structural changes which needed to come through in its financial services system. Now, in 2011, you can understand that the regulators, being the South African Reserve Bank, the then Financial Services Board, and the we actually didn't have the Prudential Authority then, sat back and looked at events like the global financial crisis, African banks, curatorship, the fact that there were lots of people in the country who were really over indebted by virtue of things like bad or poor financial advice and poor market outcomes, and decided that they were going to follow along on the global trend to actually restructure and look at financial stability overall. So what we then had was a change in the system with the SARB, who really are in charge of looking at systemic oversight of the entire financial services system, and we'd all be familiar with the SARB. And the SARB then set up two pillars. The pillars that the SARB set up were the Prudential Authority. Think of banks and life insurers, and really prudential risk. That's regulated by the Prudential Authority. The then FSB was effectively rebranded and was given a new mandate, or just a refresh on its mandate, and is now known as the Financial Services Conduct Authority. All of you would be very familiar with the FSCA already. What this means is, as financial services, we effectively are regulated and have oversight coming to us from both wings, from a market conduct perspective, as well as from a prudential regulation perspective. In addition to setting up these new bodies using the FSR Act, we've also had quite a few changes to law. And that's really why I'm quite passionate about this, but that's really what I'd like to talk to you about today. That's something that's coming down the road. Something called the COFI Bill, which is the Conduct of Financial Institutions Bill. We're hoping to see that come through within the next 12 to 18 months, either for another round of commenting or for us to start implementing. What the COFI Bill actually looks at is looking to see whether or not the regulator can regulate us on principles-based, which would be fit for the size of the institution that you are, but also really making sure that market outcomes are delivered in the correct and appropriate way for consumers. And what I'll hope to achieve today is really to draw out ethical principles and map those against the spirit of the COFI Bill. I'm sure that we'll do many more sessions regarding COFI because we'll all have to relicense, Allan Gray included, under this new piece of legislation. This is just really for us to get to grips with the fact that COFI is moving us to a point in time where we always put the customer first and think about the right thing to do. Okay, so I mentioned the word market conduct quite a lot, but what on earth does this market conduct thing mean? So market conduct really is looking at regulation, making sure that you protect the customer, you promote fair treatment of the customer, and you really look to see that the outcomes which you deliver result in sound financial decisions and outcomes for your customer. What I'm hoping is that when you hear the definition of market outcome, you link that back to something that you've already heard, either because you're quite aware of it and you've already embedded it in your practice, and those are the treating customers fairly outcomes, or because these things are what you already do on a day-to-day basis, because they could be built into your code of ethics, they are most likely built into your conflict of interest policy, or just generally are the ethical considerations and principles that you run your business by. Okay. COFI has effectively taken the TCF principles, and we'll chat through them very briefly, and has embedded them into the piece of draft legislation, but it's actually looked a little bit broader. So let's just do a quick refresh on the COFI principles. So remember that the COFI principles are really to make sure that consumers are confident that they're dealing with firms who do have the right corporate culture and have fair treatment at their core, that products and services are marketed and sold and are designed to meet the needs of the appropriate customer groups, that customers are provided with clear information and are kept appropriately informed both before, during, and after the points of sale. Where customers receive advice, the advice is suitable and they take into account the circumstances of the customers themselves. Customers are provided with products that perform as firms have led them to believe and expect, and also that customers make sure customers don't face unreasonable post-sale barriers. Those could be things like preventing a customer from switching from one provider to another, or making it difficult for a customer to complain and not really having any information on where to turn to when they actually needed or were in a pickle. Okay. So keeping those 6 COFI principles in mind, let's actually switch over to the FPI's Code of Ethics. Okay. So the Code of Ethics from the FPI effectively map directly to the TCF principles which we've just spoken about, ensuring that we put the customer first, having integrity at the forefront of mind, objectivity in decision-making and advice-giving, fairness in how we treat people and, the providers from whom you select the products and services, being competent in performing your job, and making sure you do things like getting CPD points, not across just the technical skills, but also those things which relate to the softer things like ethics, confidentiality. Yes, the bedrock and what sits behind confidentiality today are the POPI principles: diligence and professionalism. Okay. Here's the nuts and bolts of COFI. So when I look at COFI, I think about 4 things: culture and governance, business conduct, customer communication, and post-sales considerations. Because these principles might be completely new to you, I'd like to actually jump into each one in a little bit more detail. When culture and governance is thought about in the COFI context, really what we're making sure there, or the FSCA is making sure of, is that financial institutions are conducting their business with integrity, honestly, fairly, with due care, skill, and diligence. Firms should really make sure that they create a corporate culture that aims to ensure that customers are treated fairly at all times, pre-sale and post. Firms should deal openly and cooperatively with the authority as required and perform all of the activities with transparency. The next COFI principle is business conduct. When providing financial products and financial services, a financial institution, and that's you, must take all reasonable steps to avoid foreseeable harm to financial customers, must do so in a manner that is unbiased, does not unfairly discriminate against people, specifically the financial customer. The third COFI principle relates to customer communication. And this is one that you'll clearly remember from TCF, and you'll remember from a few years ago, there was a massive drive for us to write things clearly and communicate effectively. Similarly, COFI expects of us that financial institutions must ensure that products and services are promoted and are marketed to customers in a way that's very clear, fair, unambiguous, not misleading, or fraudulent. Throughout the entire process leading up to the sale of a product or service, we really need to make sure that we have adequate, clear, and accurate information going into the public domain, specifically to the end customer. This is to ensure that customers make well-informed decisions regarding the suitability of the product or service for that customer's actual needs. Another way of looking at this is really just making sure that customers are aware of all of the available facts and information that could reasonably be expected to influence that customer's decision relating to the product or service which they're being sold. Financial institutions must ensure that products and services are promoted and marketed to customers in a way that's clear, fair, unambiguous, not misleading, and fraudulent. As you can hear, there's actually quite a lot of overlap between all of the principles in some shape or form. The last principle in COFI relates to post-sale consideration. Firms need to ensure that customers have ready access to full information and effective customer services support related to the products and services they have purchased on an ongoing basis. We need to be telling our customers where to go and what the procedures are in the event that they have a complaint, and make sure that when a complaint lands on our desk, we deal with it in a fair fashion, efficiently, effectively, and transparently. Should any complaint be unresolved and lead to a dispute, customers need to be told and advised on the appropriate dispute resolution mechanism, and a lot of the scenarios which you currently are doing, that would be pointing them to the relevant ombudsman or other judicial complaints body. Okay, so those are the 4 broad COFI principles. Now, what I've done on this slide, and if you've been paying attention, which I'm really sure you have been, you'll appreciate that there's actually quite an overlap between the TCF principles, the FPI Code of Ethical Conduct and those principles, as well as the 4 overarching principles that are in the COFI legislation. So if we quickly just zip through them, when you think about putting the client first, the COFI principle that links to that is culture and governance. When we think about integrity, that could be linking it to business conduct or even culture and governance, and so on and so forth. Okay, so before I hand over to my colleague Alix, what I would like to just put out there into the public domain is that COFI is also looking to regulate financial services based on the nature, scale, and complexity of the actual entity themselves. And I think that that's quite an important consideration, because that also indicates that the regulator, wearing an ethical and having all of these fairness considerations in mind, are looking to regulate industry in that way, from a regulator to industry perspective. I know that this has been very theoretical because we haven't seen the COFI legislation. Effectively, what will happen is the phase legislation will fall away as we know it today, and those market conduct principles will be subsumed into COFI. In practice, what will happen is we'll get a chance and an opportunity to comment on the subsidiary legislation, which will be developed in the form of market conduct standards, for example, that sit underneath the COFI piece of legislation. But the bedrock when commenting and when implementing COFI is really to think of it with the lens of what's the right thing to do, and having the FPI's code of ethical considerations at the forefront of your mind. I'm sure that as industry, it's going to be a mammoth journey, and I'm really not discounting that in any way. But I think as industry, it's important to understand where the regulator's coming from, to wrap our heads around why, and then progressively and together, when we do get the opportunity to implement this, keeping in mind that this is really there for the best outcome of consumers. Please send through your questions using the Q&A box, and we'll try our utmost best to address them. And I'd now like to hand over to my colleague Alix, and she'll take you through some practical considerations relating to ethics. Thank you very much. It was a pleasure being with you today.
Good afternoon, and thank you for that, Nishaat. That was very informative and focused on the regulatory changes that will be coming in due course. I will be looking at some practical examples. So with this regulatory consideration in the background, this is to now look at some practical issues that may come up, if not on a daily basis, at least very frequently. And with these specific scenarios, it's a case of understanding, first of all, the legal implications, and in light of these ethical considerations that need to be made. So as you'll see, the agenda for today, from the practical side of things, I'll be discussing recycled brokers notes and what that means and how they're viewed. I'll then be looking at death and submitting the instructions after the death of a client, which will also tie into mental incapacity of a client and what that leaves the client with and the options that are available in order to assist the client in an ethical manner. And then to tie in with what Nishaat was touching on, I will just look at FICA and those obligations and what we're required to adhere to as accountable institutions. I'll then touch on 2 Umbut determinations that were made, which look at some of the practical examples I've discussed, and just to explain the ethical dilemmas that were faced and how these were treated first off by the FES Ombudsman and then by the Financial Services Tribunal. All right, so to kick us off, we are looking at recycled brokers' notes. So with this, it's important to consider the purpose of a recycled broker's note, but then also the issue that comes with it. So as we know, the use of a recycled broker's note is to either obtain information of a prospective client or to be appointed as an advisor for a client. However, sometimes the issue is that these broker's notes are recycled. So this essentially means that this broker's note has been tampered with, and often it's the case where a date of the broker's note has been amended on a version that's already been signed by the client. So whilst we can understand the rationale of trying to be efficient and provide a better service to the client by submitting a version that was already signed by a client, notwithstanding it having been updated, the date, the issue with that is that a document has been tampered with. So then this brings into the forefront the issue of fraud, because essentially tampering with a document would be tantamount to that. So this is, and as you'll see on the picture, it's a balancing act between understanding the purpose and trying to be efficient for the client, but then also just the implications, the possible implications of that. All of that being said, how can this be avoided? This can be avoided by having a client sign a new version of the broker's note. This will also provide an opportunity for one to meet with a client. Maybe it's a case of having an annual meeting to discuss the financial circumstances of the client and to reconnect with the client. And this opportunity can be used to have the new broker's note signed and to continue the engagement with the client. Now turning to the death of a client, which is obviously always a very difficult time. So for this, it's a case of understanding the dynamics that exist between a client and, for instance, an advisor. So as we know, there's a mandate or a power of attorney that's in place for the advisor to act on behalf of a client. That client unfortunately passes away. That will result in the termination of the mandate. So what's important to note here is that at death, a mandate is terminated. The basis for this is the South African common law principle of agency, which essentially means that if the principal, which in this case would be the client, passes away, that client or the principal can no longer delegate authority to an agent, i.e. an advisor. Therefore, by virtue of the client no longer being with us, it means that they are unable to delegate any authority, which means that mandate is terminated. So if an instruction is received after the death of a client, this essentially means that this instruction is void. So the result of this would be that the instruction is not valid and it's not enforceable. Again, the basis for this is this common law principle of agency. And since the principal is no longer with us, there's no authority that they can delegate. Something to consider with this issue is the different types of investments that a client might have and the impact that their passing will have. So I'm going to look at discretionary products first, and then I'll look at life products, and then look at retirement funds. All right, so to start off with, when we speak about discretionary products in the Allan Gray space, I'm talking about AGET, AGLP, and AGOS. So these investments upon the death of a client form part of the estate of a client. So this is when the Administration of Estates Act will come into play. Because these investments fall under the estate of the client, it is the executor who will have control over those investments. When we look at life products, we're speaking about a living annuity or a tax-free investment or an endowment. So these are governed by the terms and conditions, and in terms of which beneficiaries can be nominated by the client to receive these benefits. And then, as we know, with retirement funds, this is governed by the Pension Funds Act, and the Pension Funds Act stipulates the manner in which the benefits in those funds will be dealt with upon the death of a client. So I'm giving you this context to look at what the options are available in order to best assist a client for the inevitable passing of the client, and to be able to cater for their beneficiaries and their loved ones. So two things that can be done. So we need to ensure that the client's nominations are up to date. So that will be specifically in respect of accounts that they are able to nominate beneficiaries, because as we know, if a beneficiary is nominated, for instance, with a living annuity, that beneficiary will be able to receive that benefit upon the passing of a client, and it means that that beneficiary has been looked after. So it's important to ensure that nominations are up to date. With retirement funds, as we know, it'll be up to the trustees of a retirement fund to delegate the manner in which the death benefit will be allocated. But that being said, a member or a client is entitled to have nominees to receive the benefit, which the trustees may take into account. So something to consider when as an advisor, wanting to provide for the family of a deceased client and ensuring that they're looked after the passing of a client. Although an instruction that is received after the death of a client would be void for the reasons that I explained earlier, there are these measures in place that could assist the family of the client to make sure that they're looked after. So this would be specifically in relation to investments where beneficiaries can be nominated, which means it also bypasses having to go form part of the estate and have to be administered in terms of the Administration of Estates Act. And as I mentioned, there are some investments that will be paid directly to the estate. And in this regard, it's imperative to ensure that a client's will is up to date, to make sure it's catered for the manner in which the client would like that investment to devolve upon their heirs in accordance with their will, which the executor will adhere to. So that being said, in order to proceed with any instructions in respect of an asset that falls in the control of the estate after the death of a client, as we know, we have to wait for letters of executorship in order to accept any instructions in this regard. This can be a frustrating experience in light of the delays that the master often faces, and this is why it's not often recommended, but it's suggested that clients who have investments where they can specify beneficiaries do so to ensure that their loved ones are looked after. In the same breath, I'm going to be looking at diminished mental capacity. So again, we have this common law principle that comes into play. So we'll have our same chart. So we have a mandate in terms of which, for instance, an advisor is authorized to act on behalf of a client. Once a client has diminished mental incapacity, which I'll touch on shortly, that mandate terminates. So once a client loses mental incapacity, the power of attorney or a mandate automatically becomes invalid. So again, it's the same concept of a principal losing mental capacity, which means they're not able to delegate more authority than they have. So that is the reason that they are unable to have authority delegated to an agent to act on their behalf once they are suffering from mental incapacity. So just to explain what we mean by mental incapacity. So capacity is the ability to understand information and to make decisions based on that. Contractual capacity is the ability to appreciate the consequences of acting in a certain way. So what this means is that if a person does not have mental capacity, or if their mental capacity is impaired or diminished, they no longer have the contractual capacity. So they're no longer able to transfer any authority onto a third party. That being said, mental capacity is fluid. So for instance, if it's Alzheimer's or dementia, at least early stages of that, there are moments where a client may be fluid and may be able to understand the consequences of their actions. And in those instances, they are able to delegate authority. But that being said, the same principle applies as when a client passes away. If an instruction is received to act on behalf of a client when they don't have mental capacity, that instruction would be void. And one of the case studies that I'll be touching on will speak to this mental incapacity and how the phase ombuds considered this. I think I would like to also use this opportunity to just explain the power of attorney insofar as the enduring power of attorney. Unfortunately, in South Africa, the concept of a enduring power of attorney, which means a power of attorney that continues after the passing of a client or after they have diminished capacity, doesn't exist in South Africa, which is very frustrating. There have been reports written on it since 2004 about recommending that such a power of attorney be introduced to South Africa, but to date, it doesn't exist. So this concept of an enduring power of attorney doesn't exist in other countries, for instance, in England and the USA and Australia. But unfortunately, in the context of South Africa, the common law principle of agency comes into play, and that's the principle that I was speaking about, the agent not being able to act if the principal does not have that capacity to act. So that being said, unfortunately, if we become aware that a client has lost mental capacity, we're unfortunately unable to accept instructions in respect of this client. All of that being said, there are options available to assist the client. So again, it speaks to the desire to assist a client who's struggling, which may also apply when a client's passed away and wanting to assist the family members of a client. There are actions that can be taken to assist a client. So when it comes to mental incapacity, what can be done before a client loses capacity is to create a trust. So this trust will be able to have trustees, they'll hold the assets on behalf of the client, and the role of the trustees would be to administer those assets on behalf of the client. So essentially it will be the trust that owns the assets and who will be able to act in the best interest of the client and ensure that the client is looked after in the event that they lose mental capacity. If a client loses mental capacity and one still wants to act in the best interest of the client and submit instructions in that regard, there are two avenues that can be followed. The first is the application of an appointment for a curator. So this is done by way of a high court application and is often quite costly, but that will often be an attorney or an advocate that's appointed as the curator, and the curator will act on behalf of the client who's lost mental capacity. The alternative method that can be followed is the appointment of an administrator. This is an application that's made to the Master of the High Court, so it's a lot less costly than the application for a curator. And this is often a family member or close person to the person who's suffering from mental incapacity who will make this application. If you do require more information on this application, you are welcome to contact us and we'd be happy to assist. All right, so now looking at FICA, which we are all familiar with. So this is the Financial Intelligence Center Act. As we know, the objective of this act is to combat money laundering, tax evasion, and terrorist financing. These are the predominant objectives of the act. FICA came into effect in July 2003. According to this act, it is the responsibility of accountable institutions to ensure that they're able to identify their clients and verify their clients so that they know who they're doing business with, and to ensure that the information is correct and kept up to date. So when we look at FICA, we have to consider who does FICA apply to, and it applies to accountable institutions and to reporting institutions. So financial services providers specifically included in the definition of accountable institutions, and as such, this is why FICA applies in our realm that we deal with. So to quickly just run through the key measures of FICA. So I'm sure you've heard this concept of a risk-based approach, which is essentially the obligation on an accountable institution to ensure that they understand the manner in which either their products or services could be used for money laundering, for instance, and that appropriate measures are put in place to mitigate against the use of the products or services in this regard. Another key objective is customer due diligence. So this is ensuring that an accountable institution is aware of the identity of their client, that they're able to verify their client to ensure that they know who they're doing business with. And this also includes a single transaction and not just a continued business relationship. Another key measure is record keeping, so that's as prescribed in terms of FICA. There's also this concept of sanction screening, which may result in reporting having to be done to the FIC. And then something of huge importance is the Risk Management Compliance Program, the RMCP. So this is an obligation in terms of Section 42 of FICA. And essentially, it sets out the processes and the standards and the controls and measures that are in place by a financial institution to ensure that they're able to do their due diligence on a client, they're able to assess the risks involved with a client, and able to confirm how a report needs to be made in instances that such a report is required. So you might be thinking, how does this tie into ethical obligations? Unfortunately, with FICA, as we know, it is quite burdensome and the steps that need to be followed, but it is ethically required to adhere to that for the benefit actually of the client. So in last year, the FSCA published a list of FSPs who were non-compliant with FICA. This resulted in sanctions and fines being imposed. And the main issue that came up from this was this RMCP. So a handful didn't have a RMCP, but the majority did have one. The problem was it wasn't compliant with the FICA obligations, so those are set out in Section 42, and then also in terms of the obligations that are set out in Guidance Note 7, which are issued by the FIC. So as I mentioned, this RMCP essentially sets out the manner in which an accountable institution must conduct their due diligence of a client, which includes identification and verification of a client. They must also state how a client will be risk assessed, how the reporting will be made, and all of this to keep in line with the objective that I referred to earlier regarding FICA's aims. So this has also become much more pertinent in light of the environment that we're currently facing with grey listing, and to tie it again into this ethical dilemma of wanting to provide the best service to the client, but also complying with regulatory compliance. It's this a balancing act again. But I think what's important to bear in mind is the fact that complying with FICA, as burdensome as it might be sometimes, it is for the best interest of a client to ensure that all the due process were followed and the regulatory compliance was adhered to. All right, so now to just touch on two case studies. So the first one was a phase ombudsman determination. I'll quickly run through the facts. So the applicant in this case was the executor of a deceased client. The respondent was this deceased client's financial advisor. The client at the time was an elderly person who invested in a property syndication on the advice of her advisor. However, at the time, this client was quite elderly and she was also suffering from Alzheimer's. And factors that were considered by the phase ombudsman were the fact that no alternative suggestions were made, no alternative investments were made to this client. And unfortunately, with the specific investment, the investment failed and the entire value of the client's capital was lost. So the issue that the phase ombuds had to consider was not whether the performance of the investment. That wasn't an issue. What the phase ombudsman had to consider was whether this investment was appropriate for the client. So looking at this, we've got to conduct an analysis on what was discussed. Essentially, the factors that were considered by the ombudsman were why the respondent, as the advisor, deemed this specific investment as appropriate for an elderly woman of 80 who was already suffering from Alzheimer's at the time, whether it was appropriate from the sense that there was no diversification in her investment portfolio, and the fact that the specific property syndication was actually under inspection by the SARB, which was advertised and was being managed by PwC at the time. So in this determination, the FAIS Ombudsman focused a lot on mental capacity, which is one of the practical examples I was explaining, along with the legal concepts which surround it. And something that this court found was that the question of mental capacity is at the time of contracting. So the question that's asked is whether, and as you'll see on the slide, it's whether the mind was such that he could understand and appreciate the transaction into which he purported to enter. So it's this concept again of being able to, is the client understanding the consequences of their action when they're contracting in order to enter into this investment? With this case, the FAIS Ombudsman found that in fact the advisor acted negligently and failed to comply with his legal duties. It was because of this advice that the client elected to invest in the property syndication, despite the fact that she was not mentally capable of understanding the consequences of her actions. And the FAIS Ombudsman found that if one looked at the reasonableness of an advisor, this specific advisor in this scenario did not adhere to those reasonableness criteria. And as such, this advisor was instructed to repay the client's capital, including interest on that amount. Now, looking at our second case, it's quite an interesting one because it was initially dealt with by the FAIS Ombuds, and then it was appealed to the Financial Services Tribunal. So again, I'll just run through the facts very quickly. Essentially, the respondents in the appeal were the clients. They were pensioners who were invested, who had received some money, some of their pension money. They had contacted a financial institution to obtain some advice on what they should do with their investment. And the applicant in this case, which was the advisor, contacted these clients and provided them with some possible solutions for their investments. But these clients thought that the return rate was too low. From this, the advisor recommended or referred the clients to a property syndication. And it was this representative of the property syndication that dealt with the clients, and in terms of which the clients subsequently invested in the property syndication. So as I mentioned in the FAIS Ombud determination, the Ombud found that the advisor who referred these clients to this property syndication was negligent and actually held the advisor liable for the capital. And it was this decision that was being reconsidered by the FST, the Financial Services Tribunal. So the issue that was considered was whether what the advisor did was actually advice. Did he provide advice, or what was it that was actually conducted when he dealt with these clients? So there was a huge focus on advice and the definition of advice in terms of FAIS that was dealt with in this determination. And as we know, with advice, it's pertaining to a financial product, and it's whether a financial product is going to be invested or purchased or taken up, transacted with based on a recommendation by an advisor. So this was one of the big focuses for this case. In this case, what the FST found was that, in fact, it wasn't the advisor who provided the advice. It was rather a recommendation that was made to the clients for them to go and invest in a property syndication. In this case, the FST found that, in fact, the advisor acted adequately because he knew the extent of his advice could not go beyond, as he was not certified to give advice in the space of property syndication. So the outcome of this was that the FAIS Ombud determination was set aside and returned for reconsideration. But what I found interesting with this case was that it was a case that went on for approximately between 10 and 15 years. So the point with this, when considering your ethical dilemma when dealing with clients and maybe referring them to someone else, is just to consider the implications of that and to ensure that adequate knowledge is made in respect of the recommendation. Because as I said, with this case, it went on for a period of approximately 10 to 15 years. And even though the ultimate outcome was for the benefit of the advisor, well, it needs to still be reconsidered. This was heard in November last year and will still have to be reconsidered by the FAIS Ombudsman. It was something that took its toll in light of the huge delays in this matter of having to be dragged through it and dealing with the FAIS Ombudsman. So thank you so much for your time and for joining us. We're going to have a quick leg stretch and then we'll be back for the Q&A session. See you shortly.
Great. Welcome back, everybody. Thanks, Nishaat and Alix, for your presentations. So now we're into the sort of Q&A session of the event. Straight up, Alix, given that your presentation was lost, this question came through. And it relates to what happens at death or what are the repercussions for submitting instructions after the death of a client based on a mandate?
Thanks, Ed. So if an instruction is received after the death of a client, then as I mentioned, that instruction is essentially void. So it means it actually has no effect. We've got to unwind that instruction because there was no basis for that instruction to be submitted, which can cause issues. That's why, as I suggested, depending on the investment, the relevant investment, to rather ensure that the beneficiary is up to date. If it's a case of a client who's jumping onto the mental incapacity train, they're going that way to have a trust so that those instructions can still be submitted after a client loses mental incapacity. But to answer your question, in short, that instruction would be invalid.
Great. Also, still with you, Alix. What happens if the spouse of a client requires access to the funds after the death of a client or a client being declared mentally incapacitated?
So with that, it's a case of ensuring, unfortunately, the spouse wouldn't be able to access it unless they've been nominated as a beneficiary. But in the case of assets that fall under the control of the executor or that fall into the estate, then we'd have to wait for letters of executorship to be issued, and that would then require an executor to issue instructions regarding the manner in which that investment must be paid out for the spouse. It's an unfortunate one where a spouse is left empty-handed, and that's why it's good to look at possible scenarios or possible investments where the spouse could receive it immediately upon the death of a client and will not be left without anything while that interim period lags.
Okay. And maybe just to sort of close off on this sort of theme, in your opinion, enduring power of attorney ever existing in South Africa? Do you think it's plausible?
I hope so. It's especially when we look at the South African context. I mentioned applying for a curator is exceptionally expensive and not available to everyone. Applying for an administrator, whilst it's less expensive, there's still the burden of it. So it's nice to just have the option for some foresight for a client or a person to be able to delegate that authority and say, this is the manner in which my estate must be dealt with in this interim period between a client passing away and executive being appointed. So I do think there is huge value in that. Unfortunately, there haven't been any recent developments. It's something that does exist in other countries. So, I do hope that we will be introduced to South Africa because it has a huge need in our country.
Yeah, it certainly looks like it. Nishaat? How can smaller FSPs survive in a very burdensome regulatory environment? The changes that are spoken about, will it not force smaller FSPs to close down?
Thanks, Ed. Actually, it's a really, really good question. And interestingly, when you read COFI, and I think I ended the presentation off saying that the principle behind it is that the regulator themselves will look at the nature, scale, and complexity of the organization. So what that means is that it's not going to be sort of a cookie cutter across all organizations. So we'll all take a different way to comply with legislation and satisfy the principles in the actual piece of legislation. And I think what's also quite interesting about the way that COFI has been drafted is it's almost encouraging participation of smaller enterprises into the financial services sector. So that's also sort of another distinction to look at. But I mean, as a compliance officer, I would be remiss if I didn't say that there is a lot of regulatory change coming at all of us in industry. So Yeah.
Yeah, it's going to be tough. And then with the advent of COFI, where does phase fit into the bigger picture then?
So another great question. So COFI will harmonize legislation. So what that effectively means is there's about 13 pieces of law that will really be subsumed into COFI. So if we look at something like the Long-Term Insurance Act or CISCA, which is one that we're waiting with bated breath to see what happens, or the Pension Funds Act, everything that has to do with market conduct will effectively get sucked out of those pieces of legislation and will have COFI. Phase is an interesting one though. Phase will be repealed and everything related to phase will sit in COFI. So everything from our licensing, you need to have a compliance officer, governance framework that we need to have in terms of COFI now, those things will live in COFI.
Okay. Outcome 6 of TCF, it speaks to clients not facing unreasonable post-sale barriers. Who decides what is unreasonable?
So in COFI world, and Alex, please feel free to jump in here as well. So, these are some of the comments that, that we have also put through to the regulator. And I think in that scenario, you'd have to look at the reasonable, investment manager or provider and the reasonable client. And I think that there's definitely an element of really keeping your wits about you, when you navigate your way through it.
Maybe to just add to that, speaking to ethics, like considering your ethical principles, having a look at that, and from there, basing your judgment off what is reasonable.
Okay. With politicians moving money around the country in corrupt ways,
Yep.
Will the law be able to hold the banks accountable?
Yeah, absolutely. Yeah, absolutely. And I think that that's really the purpose of that's really effectively the purpose of all of the changes that we've seen in FICA, that have come through with the General Laws Amendment Bill. And what's really interesting and what's also quite important is immediate outcome 7, and that's taking it one step further. So we've done as industry absolutely everything that we can do, provided we've taken those things and have implemented them in our organization. The next step, though, is really just making sure that the various government agencies follow through on things like suspicious transactions reporting, flags that would come from an Auditor General, for example, and hold those accountable institutions responsible for allowing those illicit funds into the system to begin with. And I think just as industry, just a word of caution and something that I'm very mindful of is, because we know that there's enhanced scrutiny on regulators themselves, I think that all of us will experience the regulator really wanting to look under the hood of our AML practices, and we'll see quite a few AML visits in the coming future.
Okay. Consequences for individuals and reps as a result of the new legislation, and then the relicensing that you mentioned earlier?
Cool, another good question. So I can't really speak to the actual nuts and bolts and the consequences of them, because what we have is a framework of the legislation and we don't have the subordinate standards. But effectively, I think that the fit and proper requirements will look the same. From a relicensing perspective, there'll always be a transitional period. And, we've come out of this as the insurance industry, and there was a very well-run and informed methodology for, getting life insurers to relicense. And I expect the same will hold true for COFI and relicensing.
Okay. So I got asked this question actually last week by an advisor. How does Allan Gray get involved in holding the government accountable to ending corruption?
Yes, so we were invited last week actually to, no, it wasn't last week, it was 2 weeks ago, to a really great symposium, a financial crime symposium that was hosted by the FSCA and the Northwest University. It was an event that was on an invitation basis, and there were a few big banks and a few asset managers. But interestingly, there were other law enforcement agencies, and the judiciary was involved, and the National Prosecuting Authority was there in addition to the Auditor General's office. It was really cool because there were even people from the FBI. So, never interacted with them before. But the principle and the purpose behind that was for us to actually have a no-holds-barred conversation of what's actually going wrong. And for us to say and speak about things, where we were seeing pain points, and have a very honest and truthful discussion. Chatham House rules applied, so I can maybe speak a little bit about what happened, but I can't say who said what. But there are mechanisms to do that.
Okay.
Yeah, and that also comes through. Sorry, one last thing in our regulatory lobbying. We're quite aggressive in our regulatory lobbying as well to make sure that all the burden doesn't sit with us as the FSPs, and the regulator shouldn't be regulating via us. And really making sure that that responsibility for regulation and oversight also sits with them. That's quite important.
It's good. It's conversations are important, and that it doesn't come across as being one-sided. Alix, for you, can brokers' notes be open-ended until the client cancels it?
No, so it would have to be on an annual basis, just to ensure that authority is still up to date. And this is where, again, it's using an opportunity to touch base with the client again, to discuss maybe their current financial status, and any further investments that they'd like to make. So it's that also connect opportunity, but yeah, so they wouldn't be indefinite.
Okay. And then how does the broker process the death claim if they no longer have a mandate?
So this would depend, on the different product that's involved. So if it's a case of notifying, for instance, Allan Gray, that the client's passed away, then steps are in place depending on the relevant investment that this client was invested in. If it's a case that the advisor was appointed as the executor as well, then the advisor would have to go and obtain the letter of executorship in order for them to act in that capacity. But as I mentioned, at death, there's no more mandate, there are no more instructions that can be submitted, for instance, for switching investments or making withdrawals. It would have to follow the due processes according to which investment the client was invested in.
Okay. So maybe sort of tied into this, you mentioned now if the advisor is the executor, the question here is, on death, if the IFA is also the executor, will the mandate still be void and will fees still be valid?
Yeah, unfortunately, yes. And again, it's this concept of the common law principle of agency. So if we look at a timeline, a client passes away, that mandate terminates immediately. The fact that an advisor is appointed as the executor is great, and I think it's a very good choice because the advisor will be familiar with the current circumstances of the client. But the authority of an executor, no matter who it is, to act in that capacity as executor only occurs once those letters of executorship have been issued by the master, and it's not an Allan Gray rule. Unfortunately, it's in terms of the Administration of Estates Act that the assets that are held by a client at the time of their death will not be under the control of the executor until such time as those letters of executorship have been issued.
Okay. Nishaat, this is for you. So the question here is, in the phase guide under section 7.4, there's a requirement for FSPs to provide clients with a schedule of financial products held at least once per year. Does the draft COFI bill include the above, or has it been expanded on in any way?
So it doesn't include it yet at this stage in a lot of detail. So just to explain why, the COFI Act really is the overarching, it's almost the skeleton of market conduct legislation. And what we'll see are underlying, what are they called? We'll have subordinate legislation to the main piece of legislation, where items such as that will follow through. But just to tie back to a question earlier on reasonableness, in the unlikely event that this isn't a practice that's actually brought into the new COFI world, if this is a practice that will help establish reasonableness and establish that an advisor has done everything that they needed to do, then it's likely that that's a practice that will stay. I don't foresee, a wholesale change to a lot of what it is that we know in phase. I expect that we'll see quite a lot of it, but just living in subordinate legislation.
Okay. This one feels unavoidable, and and we're going to it is going to be covered next week. So also don't want to take other people's thunder away, but the questions come through: how would grey listing affect your global funds?
Okay, so this is definitely something that we're going to discuss in more detail next week. So I'm going to be quite respectful to my colleague, but I appreciate that we need to get into it. So the global funds that are offered by Allan Gray are offered on the offshore platform, so the Aegis platform. And we have proactively engaged, and because we basically anticipated that this might be a likely outcome. So we've engaged quite robustly with all of the offshore managers who host their funds on our platform, as well as their transfer agents. At this stage, we don't foresee that there will be any massive shift and change on the expectation for underlying clients. In terms of the 5th European directive, they might be under an obligation to actually ascertain who sits in their fund and holds more than a certain percentage of their fund. But that's information which we should have and should be able to pass through to the administrator and the manager. So we've tried to deal with it as proactively as possible. We continue to hold those conversations. There will be an impact on Aegis, the entity itself, but that's something that we'll deal with from an internal governance perspective, where we ourselves will have to provide information relating to the Allan Gray entity to these foreign managers. We're hoping that the risk ratings already happened and they're comfortable with our RMCP, which we have shared with them.
That's enough, yeah. I mean, hopefully that's the outcome. Thanks. Thanks, Nishaat. That's a wrap. Thanks, Alex. Thanks for your time. Just as a reminder, we are in the process of certifying the webinar for CPD hours. And once we've got those, we'll distribute it. And also note a survey will pop up at the end of this webinar. So if you could please take a few minutes just to complete it for us, we appreciate the feedback. And thanks again for your time.